here at the scene of the crime spree, right behind me.
Strange. Vice Mayor Strange, you'll address her properly.
You can kiss my foot.
Mr. Rickard, you're out of order.
FBI, we are asking you to investigate this council. Please look into this council, how they award contracts, the bid process, how they use their positions to benefit their friends and themselves, how they use their positions to attack residents and critics and neighbors and business competition. FBI, will you please look into this?
And I welcome the FBI here. If you notice, Mr. Thompson, with his plea for the FBI and his watchdog group, this city runs the cleanest in this whole county. I guarantee
He was served a federal subpoena this morning.
Did receive a subpoena this morning, and we're going to cooperate 100% with the subpoena. And
Most of you who were involved up here, you gaslighted me. You tried to say I was crazy. And now we know that that's not true. And there's a lot of other issues I've been asking about as well.
I spent some time in Tallahassee this week on Monday and yesterday because the Lynn Haven corruption case is heading toward trial, or it's at the final stages before trial. And you may recall the Lynn Haven corruption case. It involved fake companies after the Hurricane Michael, and it involved people creating fake companies, and the city attorney was arrested, Adam Albritton. The city mayor, Margo Anderson, was arrested. A bunch of people, and also developer James Finch was arrested. And basically, most everybody pleaded guilty, including the city attorney, Adam Albritton. The only ones who did not plead guilty were developer James Finch and former mayor Margo Anderson. They didn't plead guilty. That means that they're not getting any kind of special deals for admitting guilt or, testifying against other public corruption. They're going to trial. And the FBI, or the feds, have a very high conviction rate. People like to say it's a 98% conviction rate. Now, a lot of that is because the vast majority of people charged will plead. I don't know what the conviction rate is for an actual trial, but it's. I don't think it's going to be 98%. It will still be decided by a jury of their peers. The case against Margo Anderson, the mayor, and James Finch, the developer, is super interesting. It has to do with charges of conspiracy for fraud, bribery, this type of stuff. And this is really unusual because the developer, James Finch, he filed a motion to dismiss the case. The defense is saying that they weren't getting exculpatory evidence. So when they were charged, they're supposed to receive all of the evidence and discovery from the feds, right? They're saying that there are Brady violations, meaning that the feds have not given them evidence that would be exculpatory, right? That might show that they didn't do what they were charged with doing. And there are several other things that have come up. So this was what I went to this week was known as an evidentiary hearing, right? Where the judge will consider evidence to include testimony, to include written evidence, notes from the FBI, and also, in another very unusual thing, the defense, their allegations were strong enough that the federal judge, Chief Judge Mark Walker, allowed, first of all, he had to compel the feds to turn over more evidence to the defense. He had to compel them to do that. Many of these documents are known as 302s, and these are interview note papers. Whenever the FBI interviews a witness or a target, what we might call a suspect, they memorialize these interviews on a form called a 302. And it's a super powerful tool for the prosecutors, and an important one for the FBI. You know, if they're talking to somebody, they might be scribbling notes on a pad, but then they take those notes and they formalize them in the Form 302, and then they file them and they become official. And they can be used, these 302s can be used as powerful evidence against defendants. If you're interviewed by the FBI, the FBI goes back to the office, and hopefully within that day or the day after, they will memorialize the interview in a formal document called a 302. The person who was interviewed never sees the 302. You never see it unless you are indicted, right? And your defense lawyer will receive in discovery the 302s, what was said, so that you can mount a defense. So this was really something. So understand that what I went to Monday and Wednesday is called an evidentiary hearing. So when the developer James Finch filed a motion to dismiss, the judge said, before I make a ruling on this, I want to see some actual evidence. All right. Show me the evidence. And it was a 3-day evidentiary hearing. The first day was Thursday. I didn't go Thursday. I didn't realize there would be live witnesses. I thought it would be a short little hearing. But when I found out there were witnesses, I went Monday and I went Wednesday. I'm going to tell you what I saw. You can't bring a camera in a federal courtroom. You cannot record or take pictures in a federal courtroom. You'll see, if you ever see court video, that's because it's a state case. It's not a federal case. If you ever see those sketches in a courtroom, that's a federal court. All right. So I didn't make any sketches, but I did take a hell of a lot of notes. I filled this thing up, both sides. I mean, I'm scribbling notes. The Beacon of Bay County, that crew was there. They were reporting on this. And also WMBB was there. Brady Calhoun specifically was there. He was sitting in I don't want to say the audience, but he was sitting in the benches in the back, right over there. So he saw and heard exactly what I saw and heard. This is really incredible. And by the way, and I'm going to show you WMBB's reports. We're going to look at them together. They are flat out lies. WMBB is flat out lying to you. The headlines are journalistic malpractice. If you had seen the evidence in the courtroom that was presented, and I'm talking about transcripts, here's what I was going to tell you. The judge not only had to compel the feds to give the defendants all of the documents, the 302s, the judge also, and it's not unprecedented, but it's very rare, when the investigators and the witnesses and the prosecutors go and talk to a grand jury in an effort oftentimes to get an indictment, that's secret. You don't know who's on the grand jury, which is composed of, I think, between 18 and 24, something like that, about 20 regular people. A grand jury is convened. It lasts about 6 months. If you're on a grand jury, you don't tell anybody. They whisk you in and they whisk you out. And there are about 20 of you, regular people. Nobody's trained in any of this, regular folks. And you are on a grand jury grand jury lasts for about 6 months here in Florida. This case took so long that there were actually 3 different grand juries, right? It took 3 grand juries. Well, the defense was, and in a grand jury, by the way, when in an attempt to get an indictment, there are no judges. There are nobody from the other side. The grand jury only hears one side of the story. Okay, so the grand jury in this case only heard the feds and the sheriff's office, which was working jointly in this case, which is another very unusual thing in the Lynn Haven corruption case. And by the way, I want to point out that there was clearly public corruption. There was clearly theft. There was a lot of stuff. And most of the defendants pleaded guilty, right? So there was absolutely corruption. The question remains now, was there a federal conspiracy to bribe and commit fraud by the former mayor Margo Anderson and James Finch, the developer? That's the question that remains, okay? And I'm going to go over some of those details in the course of this. But again, what this was not a hearing. I'm sorry, it was not a trial. It was a 3-day evidentiary hearing so that the judge could gather the evidence to issue a ruling on whether or not to dismiss the charges. Dismiss with prejudice, which means that if the judge dismisses with prejudice, that it goes away. There's no second bite at the apple. It's done. That's what it means, with prejudice. If you ever hear of a dismissal without prejudice, it means that there could be another case mounted. Okay, so like I'm more familiar with it in a civil sense. Since I'm Bernie the attorney. I'm not an attorney, but I play one in real life when I get sued for defamation, like James O'Keefe, and win. So I've defended myself, and I've had to learn about these things. And if somebody dismisses the case, like they did against me, with prejudice, that means they can't bring it back up again. If they dismiss it without prejudice, we may come back at you again, pal. See, so this is a motion to dismiss with prejudice, and the judge wanted evidence. So there was a 3-day evidentiary hearing with live witnesses, to include the FBI agent, to include the sheriff's investigator. It's unbelievable. I'll tell you about this. So WMBB is and you would think that if the FBI had federal charges against a mayor, that there would be news outlets in the evidentiary hearing. There was only one, aside from the Beacon of Bay County, which is doing great. And my little janky operation, as Mike Thomas used to call it, the former mayor of Panama City Beach, only WMBB, and it was Brady Calhoun. And they lied to you. They committed journalistic malpractice. At the very least, they lied by omission. I'll show you. So now where are we at in this? So the judge concluded the 3 days of the evidentiary hearing. And now both sides, the feds and the defense, are going to, I want to make sure I say this just right. Well, here's what's at issue, right? Here's what's at issue. If the judge decides that these things happened, he could, as a matter of law, dismiss this whole thing. 1, Sixth Amendment violation. Specifically, attorney-client privilege breaches. Okay. Number 2, what the judge will consider is whether or not dozens of false statements to the grand jury, allegations, were just neglectful, false statements to the grand jury. Were these false statements, dozens of them, were they simply neglect, or do they rise to a pattern of willful mischief in order to obtain an indictment? Okay, if the dozens of false statements and allegations against the defendants, if those were just neglect, that doesn't rise to the level. The judge won't dismiss it if it's just neglect, mistakes, sloppiness. But if the judge determines that these were willful, it was willful mischief in order to obtain an indictment, he can, as a matter of law, dismiss it. So those are the two biggest things that the judge will be deciding based on the written arguments that will rely on case law on those issues. All right. So that's where we are now. What I want to do is I want to show you. Well, no, I still want to explain more to you about this. I want to lay this out a little bit more because there are three projects. There are three projects that are at issue, and these projects that Lynn Haven was engaged in began in 2015 and went all the way up to, I think, 2019 or so. And I will give you details about those projects and tell you exactly what, because you didn't get it from WMBB. I'm going to tell you exactly what the judge said and what's happening now and what's coming next right after this.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
It's a hot time in Florida, and my friend Ryan can make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com. All right. So the three main projects that are at issue here are in chronological order. The 17th Street Stormwater Drainage Project. Number 2, the half-cent sales tax. And number 3, the rebuild and FEMA reimbursements. Okay. These are the three projects at issue. Now, within those three projects, there are many issues. Okay. And these issues pertain mostly to former Mayor Margo Anderson. And these are issues that you may have read as charges. These are the things that she's being charged with. Okay. They include things like this. Things like one charge is that she had the city itself did debris cleanup on her property after Hurricane Michael. All right. That's one of the charges, that she had the city, that she directed the city to clean up her home, her property area, with the debris that was all over the place. That's one of the charges. It's one of the issues. Another one alleges that she got free service or agreed to a pro bono contract with World Claim Insurance. If I decide that the city is going to use World Claim Insurance, then I get a kickback, and that's free service from World Claim. Okay, that's another one of the issues, the charges against her. Another one is the motorhome that the feds allege that Mayor Margo Anderson, former mayor, was given a motorhome from developer James Finch, who got giant contracts from Lynn Haven at her direction. Okay, that's another one. Another one is, and here's some context. James Finch has been best friends with Margo Anderson's husband for more than 30 years. I mean, best friends. Okay. So they have a long time relationship. That muddies things. Now this is my personal opinion. It's my personal opinion that it's wise to either be, and Margo has also super good friends and has been for many, 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 many years with developer James Finch. It's my opinion that you should either be the mayor or best friends with a developer who gets a bunch of big contracts from a city. It's not illegal, but I think this shows why it's wise not to do that, if only for appearances of impropriety. But I want you to understand the context behind this, the long-term relationship between Mayor Margo Anderson and developer James Finch. So she's also accused of traveling on vacations on James Finch's private jet. In fact, the FBI told the grand jury that it was $40,000 worth of benefits, gifts, that's how much the flights were worth, $40,000. Okay, that's another one of the charges. This all sounds pretty bad, doesn't it? So these hearings were an opportunity, a rare opportunity in cases like this, for the defense not to argue in the sense of just saying it didn't happen, but to actually show evidence, the 302 FBI notes, the transcripts from the grand jury, and other evidence, timelines, right? This was a chance to show actual evidence that could refute, in absolute terms, the charges. So this is what this was all about. All right. So let's see here. All right. So I'll just say a little bit more, and then we're going to go right to how WMBB reported this and why I'm saying that WMBB absolutely lied to you, if only through omission, but also through deception. Okay. WMBB has been after Mayor Margo Anderson. For some reason, they wanted her out. Okay, they were involved in this very much. Now, you might say, in fact, they provided evidence to the FBI. So you may say, well, Bernie, you've been after people too. And I have, haven't I? Public figures, elected officials. Take Mike Thomas, for example, the former mayor of Panama City Beach. I've told you he's corrupt. I've shown you crimes that he's committed in meetings, specifically trading a road for a vote. But if Mike Thomas had been arrested or gets arrested, if Mike Thomas gets arrested by the FBI and he's being prosecuted by the U.S. Attorney's Office, and they accuse him of doing things that I know he did not do, do you think that I would tell you that? Or do you think I'd pile on? I would absolutely tell you that that didn't happen and that Mike Thomas is not guilty on that charge. But WMBB is not doing that. That's the difference. WMBB knows better. They saw what I saw, and they are lying to you about some of this. All right. So remember, before we get to the story, in this case, the defense was trying to show in the evidentiary hearings this week that the prosecutors have withheld evidence that could be exculpatory. That and now, right now, when the judge gets the final paperwork and the arguments based on case law, the judge will decide whether or not it's true and whether or not it rises to the level of dismissal as a matter of law. All right. So let's take a look at the one of the stories we're going to look at two of the stories. One, I didn't go to Thursday. So we'll look at, let's look at Thursdays first. And then we'll look at what they reported about they didn't go to Mondays. I didn't see WMBB at Monday's evidentiary hearing, but I did see them at yesterday's evidentiary hearing. So we were there together yesterday. But let us first take a look at what they reported on Thursday, the first one. And I wasn't at Thursdays. All right. Oh, you know what? I want to actually let me do this over. Hang tight. I want to make sure there's no volume on these. So let me do this one more time. Let me share this screen with you one more time. All right. This way we don't have any volume. All right. So this is WMBB's story. Look at the headline. Lynn Haven defendants point fingers at another contractor. Point fingers. That's the headline. The defendants are there to show evidence. Evidence. This is the Chief Judge Mark Walker doesn't play. He doesn't allow anybody to sit in there and point fingers at each other. What he's interested in is evidence. Okay. So let's take a look at how WMBB report. Look at the headline. Lynn Haven defendants point fingers at another contractor. Now, does that make the defendants look guilty? You're damn right it does. And they might be. I just haven't seen the evidence yet. Here's how they report. The ongoing corruption case in Lynn Haven ensnared several new players Thursday, a week ago, after the defense suggested that there were corrupt local. They didn't suggest, by the way. They provided evidence to include testimony that there were corrupt local and federal investigators and prosecutors. Mayor Anderson, the former mayor of Lynn Haven, and James Finch, the owner of Finch Construction, are accused of bribery and fraud over several projects in Lynn Haven. The ones I mentioned, the 17th Street Stormwater Project, the half-cent sales tax, and the rebuild and FEMA reimbursements. However, WMBB reports, during a day-long hearing last Thursday in federal court in Tallahassee, where I was not there, their attorneys pointed to witness statements that accused Derwin White, the former co-owner of GAC Construction Company, of being the godfather of Bay County. Now, I'm told from people who were there that it was not the defense that called Derwin White the godfather of Bay County, but it was the prosecutors who said that. So that's not an accurate statement. The statement said that White bribed local investigators and prosecutors. White died unexpectedly last year. Finch's attorney, Guy Lewis, also accused federal prosecutors of using an informant to gather information from suspects after the suspect had obtained a lawyer. That would be, if that's true, that would be a Sixth Amendment violation. The defense attorney argued that this would be a serious violation of attorney-client privilege. So Judge Mark Walker is very good at this, Chief Judge Walker. What he will say, he will repeat in his own words what one side is saying to show that he understands the point. Okay? He'll say, so Judge Walker said, somebody had their nose under the tent is what you suspect. All right. It doesn't mean that's true. That means he's summarizing the point made by the defense. Prosecutors denied this claim, saying Derwin White attempted to tamper with witnesses. Okay. So the prosecutors are saying that Derwin White did attempt to tamper with witnesses. In fact, his nephew, Mickey White, the owner of ECS, the company, well, let me just keep reading, testified that his uncle bragged about bribing people. He did a lot of that, said Mickey White. He bought a lot of people, a lot of stuff. Mickey White owned a separate construction company, ECS, and has already pleaded guilty in the corruption case. Mickey White testified that he believed his uncle, Derwin White, was getting information about the case from a local investigator. That information included verbatim questions and answers that Mickey White had provided. He also testified that Derwin White told him to create invoices. This is important now. For work done at Margo Anderson's home. That's one of the charges against her. Derwin White instructed Mickey White to bring him those invoices that night and to have a copy of the invoices in his office. Derwin White allegedly told Mickey White that an FBI raid was coming. Mickey White said the FBI showed up the very next day. The defense attorneys suggested that these invoices were fraudulent because Mickey White testified that they were based on other reports about work done at Anderson's house. There is reportedly another set of invoices involving Anderson that were found in a trash can at ECS offices. The defense argued that Derwin White was connected to his alleged criminal activity with Chris Forehand. Forehand is an engineer for the city of Lynn Haven and is expected to testify against Margo Anderson and James Finch. Prosecutors have reportedly offered him immunity for his testimony. What happened on Thursday last week is prosecutors gave Chris Forehand full immunity. Full immunity. Chris Forehand was being investigated for ill-gotten gains in the millions and millions and millions and millions and millions and millions of dollars. But he got full immunity last Thursday. They also argued that the defense, that Mayor Anderson was the whistleblower in the case, and that the city followed the law until Mike White, another White, there's three Whites here, Mike White, unrelated by the way, the former city manager, took over. White has pleaded guilty in this case, the former city manager. According to Anderson's attorney, the city was run correctly before White was hired, but while Anderson was still mayor. He said, "What?" And this is an allegation. Well, Michael White did plead guilty, so he is a criminal. What changed is that Michael White is a criminal. It's a factual statement. This is journalistic malpractice. Okay, remember, I have a master's degree in journalism from USC in Los Angeles. On the very first day I ever went to class, the professor told us, longtime journalist, he looked like Papa Smurf, by the way. He's a little old, crusty guy. Looked like his fingers had been beaten on typewriters for decades and decades. He said, we do not use adjectives in a straight news story. All right, because it slants the point of view. And a reporter is supposed to not just give the facts, but to give the facts in context, to tell the story accurately, and to do so using a word like explosive in this particular sentence is journalistic malpractice. Despite all of this explosive testimony, let's see if WMBB calls the prosecutor's statements explosive, or do they only say it about the defense? That is not accurate reporting. So WMBB says, despite all of this explosive testimony, this part of the case will be decided on several issues of law. So the defense attorneys are hoping that Judge Walker will throw out their case, either because the prosecutors returned another indictment that fails to pass legal muster, or because they failed to produce legally required documents to the defense in a timely manner, which is a Brady violation, and could lead to a dismissal as a matter of law, by the way, or because they violated the law during the grand jury process. Grand jury proceedings are usually secret and sealed, but the defense convinced the judge to unseal them so that the defense could make his arguments. That's not exactly why Judge Walker did that, but we'll get to that a little bit later. Judge Walker acknowledged that this was highly unusual, but he said, here we go. But he said he wanted to deal with all of these issues so that another court, an appeal court, if they're found guilty and they appeal, would have everything on the record during a possible appeal process. The judge added that it was as if the attorney, I'll read it, hell. Judge Walker said, it was as if the attorney said, the defense, "Judge, I found a dog's tooth in my chili. I'm probably going to let them look in the kitchen," right? There's something really wrong here. We got to find out what's going on. The defense attorney, Lewis, said he believed the prosecutors were reckless, if not malicious, when they got the latest of 3 grand jury indictments in the case, the transcripts. Here is what the defense attorney said. I'm saying that they got it 100% wrong on these two, the first 2 grand juries. and they are completely incorrect. He draped his arms over Finch and Anderson's shoulders. However, the judge and the prosecutors pushed back and noted that the bar for such an argument is very high. That is an inaccurate statement. The judge doesn't push back against either of them. He's not allowed to. Now, the prosecutors can push back. The judge can say that the bar is very high, but Judge Walker didn't push back. That's inaccurate. That makes it look like the judge is on the side of the prosecutors. That is not an accurate statement. Prosecutors would have to knowingly, this is true, have misrepresented the facts in order for a judge to throw out the indictment. The misconduct by prosecutors included a litany of leading questions, mistakes. Here's what WMBB says, mistakes. So WMBB has already decided that it was merely neglect and not willful mischief over the evidence and a rushed process. Defense attorneys argued, but it was rushed to the point that the jurors could not possibly make an informed decision, said the defense, about the complicated legal matters before them. You know how long the jury was out? A whole 2 minutes, said the defense. 120 seconds. The defense also railed against prosecutors for introducing a letter to the grand jury. I don't consider this stuff to be that big. This stuff here is really not going to be an issue in the judge's decision. So I want to move to what happened yesterday, because I was there yesterday, and I want to talk about that. All right. So now I'm going to pull up WMBB's latest story, and let's take a look at the headline. Now, I was there yesterday. We're going to take a look at the headline, and we're also going to take a look at how WMBB reports what happened. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm El Saulene, your Panama City Beach lawyer. 850-215-0628.
Okay, so remember, WMB reported last week, the headline was, Lynn Haven defendants point fingers at another contractor. All right, so let's see what the headline was for yesterday's hearing. Well, hell, look at this. Lynn Haven defendants attack the indictment and investigators. They attack. This is really, really remarkable, these headlines. All right, so let's read it together. This was the hearing yesterday at the evidentiary hearing where I was, and WMBB was also there. By the way, wouldn't you think that when a mayor is being charged of these types of crimes, that there would be all the local news outlets? This is an evidentiary hearing. This is damn near like a trial. But there weren't any. There was the Beacon of Bay County, there was WMBB, and there was me. This is one of the reasons, this is one of the biggest problems, not only in America, but locally, that news outlets aren't reporting actual news. They're not even there. All right, here we go. A 3-day hearing, this happened yesterday, in the Lynn Haven corruption case that a federal judge described as extraordinary, concluded yesterday in Tallahassee. By the way, Judge Mark Walker called it extraordinary, not because the crimes were so extraordinary, but because the questions involving the prosecution are so extraordinary. But you don't really get that when you read the lead sentence. Defense attorneys for former Lynn Haven Mayor Margo Anderson and James Finch, who was the owner of Phoenix Construction, continued to attack the bribery and fraud charges against them. Not refute, but attack. That's how WMB reports this. The attorneys took issue with actions by investigators, statements to the grand jury, and the actions of one witness, former prosecutor Greg Wilson. The defense alleged that Wilson was used as an informant by the FBI and used to get information about the defense in violation of attorney-client privilege. Here is an absolute lie by Brady Calhoun and WMBB. They report that it is a claim that FBI agent Lawrence Borghini denied on the stand yesterday. All right? That's not true. What Borghini denied, what the FBI agent denied, was violating attorney-client privilege. He also denied that Greg Wilson was a formal cooperating informant. But he said, and he described how Greg Wilson would provide information that he was getting from Derwin White about to FBI agent Lawrence Borghini. So the FBI agent never said that he wasn't getting information from Greg Wilson. The FBI agent said that it was not information that was attorney-client privilege. So the FBI is refuting what Greg Wilson said, not that Greg Wilson was providing information. These are important points, those 2 points. The prosecutors say he was not a formal informant, but they did not say that he wasn't an informant at all. But WMBB wants you to believe that. In another extraordinary moment, the FBI agent, the lead investigator on the case, who, by the way, is retired now, he retired at the very end of last year, testified that he was unaware that federal prosecutors had called Finch and Derwin White, the co-owner of JC Construction, the, quote, goal of the investigation. In other words, this is not good it's a bad day for the prosecution. Remember the TV show Law and Order, right? The police, they're the ones who investigate and make the charge. The prosecutors are the one who prosecute the charges, right? So they're separate. The FBI and the state attorney, the prosecutors. What was extraordinary is that the FBI agent said that he did not know that the prosecutors told the grand jury that James Finch and Derwin White were the prime targets. And that made Judge Mark Walker, by the way, say, wait a minute. You're telling me that the FBI didn't know that Finch and White were the main targets of this investigation? Let's just say that Judge Walker looked incredulous at that point. Prosecutors made the statement to the grand jury in June of 2020. But a month later, the FBI agent told Finch that he was only a witness. That's not all that the FBI agent told Finch. According to the 302 document that was shown in court, what the FBI agent told Finch when he interviewed him and delivered some subpoenas, the FBI agent told Finch at the end of delivering that and talking to him, Finch said, am I just a witness or am I a target? Because if I'm a target, I'm going to need to get a lawyer. And the FBI agent said, according to the document, the FBI's document, well, if you get a lawyer, that's going to change the nature of our relationship. But the point here is that a month after prosecutors told the grand jury that Finch was a target, more than a witness, a month later, the FBI told Finch that he was only a witness and therefore didn't need a lawyer. That is a very, very, very big deal, but it only made a tiny part of this story. Judge Walker said, it is pretty important that the lead investigator of a federal agency did not know that Finch was a target. Yeah, I'll say that's a big deal. In another unique moment, WMBB says, the FBI testified that Wilson, a former prosecutor, came to him with information. Remember, this is the guy that wasn't the formal informant, but was passing along information to the FBI, came to him with information about alleged corruption at the state attorney's office. That would have been Glenn Hess's office at the time, now currently Larry Bassford's office. The FBI agent said he took all of Wilson's information and filed it away for a possible future investigation into the office. Now, that was, by the way, I believe that was, that was way before, by the way. But however, that investigation never moved forward, said the FBI agent. The defense also brought up, now look at this, how WMBB writes this. The defense also brought up an untrue claim Wilson had made. So the prosecutors, what their goal was at yesterday's evidentiary hearing was to discredit Greg Wilson, who was providing information to the FBI. That was their goal. So WMBB also, it's clearly their goal. I don't know. I'm only telling you what I saw there. But WMBB says the defense also brought up an untrue claim Wilson had made that Finch had hired a private investigator to record who was coming and going from the FBI office in Panama City and Bay County Sheriff's Office in Lynn Haven. The FBI agent did not answer as to whether or not he believed that claim, but said he never investigated the issue further. Now, the judge was curious, and the defense was curious. So you were told that the sheriff's office and the FBI office was basically under surveillance, and you decided just not to do anything about it? You just didn't do anything? Did you not believe him? And the FBI agent wouldn't answer whether or not he believed him. He just said, I filed it away. That's it. That was a hard moment to believe. Let's put it that way. The defense attorney took issue with the FBI's handling of that. He noted that the FBI never made Greg Wilson fill out a form that said he waived his rights before talking to the FBI. Now watch how WMBB downplays this. The FBI countered that Wilson, an attorney and former law enforcement officer, was well aware of his rights. He was more than that, by the way. He was also the second in command at the state attorney's office. He was a top prosecutor. The FBI added that he believed Wilson had filled out the form on the same day while in custody at the Bay County Sheriff's Office. This is another sticking point that could come into play on whether or not this is dismissed. Because according to the defense, and I don't know if this is true, but the FBI agent did not refute it. There's a form that must be filled out. You can't just say, well, the person I'm talking to that is singing, he knows his rights, so we don't have to formalize it. That's a sticking point here, but not to WMBB. The defense also said that the FBI's reports in the case sat idle and in some cases were not properly filed for 2 years. This is another very big deal. The FBI, remember, when they interview somebody, a witness or a target, they scratch down notes on a pad and then they go formalize it, usually the next day or very soon. And then so it becomes official. But there were times that the FBI would interview a witness or a target, and it was not put into the proper form for 2 years. That is another sticking point. Now, WMBB goes on. What impact these issues will have on the case is unclear. The defense is hoping the judge will agree that prosecutors were reckless and perhaps even malicious, and that they violated the law and their clients' rights multiple times during the investigation. There was evidence presented. There was evidence presented that they did do that, particularly with Finch. At the same time that the FBI told Finch, you're only a witness, Remember, a month before, the prosecutor told the grand jury Finch was a target. The month after that, the FBI told Finch himself, you're only a witness. But after Finch was indicted, there was a subpoena served by the FBI to one of Finch's employees. I'm sorry, it wasn't after Finch was indicted. It was after Finch got a lawyer. Okay. And once you're a represented party, the FBI can no longer directly have contact with you or indirect contact with you, meaning your employees. The FBI said they did that. This is huge. However, Judge Walker said multiple times, notice WMPB says, however, but that's not such a big deal because the judge said multiple times that he was allowing the defense to investigate the usually secret and sealed grand jury process in order to preserve the record for future appeals. Walker also suggested the judge multiple times that attorneys should not look at his comments during the proceedings for any indication of what he actually thought about the issues in the case. Now, that was said, but the way WMBB put that in there is not completely. It doesn't make this context accurate. He goes on. WMBB goes on. The judge's thinking did seem to be on display during a presentation by one of Anderson's attorneys. The attorney argued that while a company working for the city did do work at her house after Hurricane Michael, she did not break the law. According to her attorney, the work was done at an easement that abutted her property, connected to her property, and was a city responsibility, he said. They had documents showing that the easement is not part of her property. That's the only place, by the way, that debris was cleaned up by the city. It wasn't, it was never alleged, at least there was nothing that I saw, that Mayor Anderson ordered the city attorney, Michael White, to send the city to clean up her property. There's nothing there that showed that. He also added, the defense attorney, that and this they said happened. All employees had free work done at their homes under the direction of city manager Mike White. Now, CWMB doesn't say what the judge said at that point. Judge Walker said, so your point is, because he's very good at this, so your point is that the former mayor, Margo Anderson, she didn't receive a special benefit. She didn't order anybody to give her a special benefit. Others did get a special benefit because the city manager had all city employees. He helped all of them get their work, their homes picked up, their property picked up after the hurricane. But the judge said, but you're saying, defense, that it was not a special benefit to her and it wasn't even on her property. See, WMBB doesn't say there what the judge said, do they? At another and I'm telling you this, I'm telling you this because if this case is dismissed, and it could be, I want you to understand why. Because if you only read WMBB, you're going to be shocked. I'm telling you, don't be shocked. If I'm a gambling man, and I am, I think it's still going to go to trial. Okay. So if I'm betting on this, I'm not telling you that I don't think this is going to go to, I'm not telling you I think the judge is going to dismiss the case. All right. If I had to bet, I bet it still goes to trial. But what I am telling you is I will not be shocked. I mean, it's a close call. I will not be shocked if it's dismissed. The evidence was that powerful. It was so powerful, by the way, that when the defense was done and the prosecutors repeated their statement that Greg Wilson was not a formal informant, a formal cooperating informant, they didn't deny he was given information. They stopped. And the judge said, do you want to present your side? And the Fed said, no. We don't want to refute any of this evidence that the defense has presented. We'll just submit it in writing. That was less than exciting. They looked less than enthusiastic. At another juncture, one of the former Mayor Margo Anderson's defense attorney argued that it was her husband Lee who purchased an RV from Lynn Haven city employee Chris Forehand. Now, I'm not clear exactly if the RV went from James Finch to Chris Forehand, who was hired, who was the city engineer, to Margo, or if it went from Forehand to Finch to Margo. I'm not exactly clear how that goes. I can't remember. I can't recall. Is that your testimony under oath, Bernie? Yeah, it is. Now, I will say that I think this is the defense's weakest point. But that's not to say it's a weak point. The other points were just so damn powerful. Let me explain. Let's go on with WMBB. Although prosecutors have repeatedly described this as a bribe from Finch, the developer, to the mayor, Margo Anderson, the defense attorney suggested that they were unfairly tying Margo to Lee, wife to husband, even though she may not have always known what they were doing. But the judge noted, and he did, that the RV was community property, regardless of whose name is on the paperwork. And then the judge said this, okay? But WMBB is again putting this out of context. The judge said, if somebody gave my wife an RV and then I rule in their favor, I'm certain I would be impeached. Yes, he said that. But what he was doing, again, was he was telling the prosecutors, or he was explaining that he was trying to understand, why, defense, are you saying that this is helping your case? Because if my wife was given an RV and I ruled in favor of the person who gave, I'd be impeached. The defense, remember, is saying, well, you don't remember because you weren't there and WMB didn't report it, that the prosecutors told the grand jury that the RV was given to her, given to the Andersons, plural, and not sold to the husband, and registered in his name with a title in his name. Okay, it wasn't given, is the point the defense was making. And so therefore, the judge's comment there is a little different. It wasn't given. Now, again, I say that this is the defense's weakest point right here, in my opinion. It was the only time during what was 4 hours or so, that the defense didn't look strong. Okay, so that's what I saw there. Former Mayor Anderson's defense team also said multiple times that she is the whistleblower in the case. This is kind of a big deal too. They note that she came forward with documents about illegal billing to the city for work done during Hurricane Michael. The defense is arguing that while she signed, this is incredible. The defense is arguing that while Mayor Anderson signed off on the checks written by the city twice a month, she was not in charge of the process. Lynn Haven, they noted, is a city manager-run government, and the mayor essentially is a figurehead, a voting member of the commission, and mostly just rubber stamps the finances. There was a lot more to that. What the government, what the feds are alleging, is that former Mayor Margo Anderson was directing former city manager Michael White, who's pleaded guilty, for his charges. They're saying that the mayor directed him to pay these companies and that she was signing the checks. That's not what happened. The evidence was shown. What happened is the city attorney and staff recommended that a company should be hired by the city. The commission voted 5-0 to do it, and that the finance office at the city, once the checks are written, guess who signs it as a ministerial duty? The mayor, after it's voted on, after staff recommends. That's amazing. That is not being told in this story. That is completely misrepresented in the story. And that evidence was shown in court. And that's not how it was presented to the grand jury. How do we know? Because the grand jury transcripts are available and they were shown. WMBB knows this. They were sitting in court with me. But WMBB again says, however, once Mayor Anderson became aware of the malfeasance, the high amount of the checks, and other stuff that we don't know that wasn't presented because it couldn't be presented at that particular hearing, she took the documents to the Bay County Sheriff's Office. This would have been April 1st, 2019. The Sheriff's Office partnered with the FBI 3 days later and began an investigation on this. After Mayor Anderson brought documents to the Sheriff's Office and said, hey, what Michael White's doing, city manager Michael White's doing, does not look good. And she asked the Sheriff's Office, please investigate this. 3 days later, the Sheriff's Office shows up. They investigate this. And, well, let's continue. Prosecutors counter that the investigation actually began before Margo showed up, when city manager Mike White was arrested in a domestic abuse case and investigators spotted suspicious texts on his phone. So before April 1st, 2019, when former Mayor Margo Anderson brought what she says she considered to be suspicious possible criminal activity to the Sheriff's Office, April 1st, 2019. Before that, Michael White, the city manager, was arrested for domestic violence. The Sheriff's Office and the prosecutors are saying, we were already onto that. We already knew about that because we had his phone, man. We had that info. We were already on it. But what WMBB doesn't tell you is that the defense says nowhere is that recorded. Nowhere is it written, formalized. There is stuff written and formalized that when they looked at Michael White's phone, that he was doing favors for people, that he was, letting people off the hook for tickets and stuff like that. But nowhere, only after the fact, did the Sheriff's Office say, we were already onto that. She wasn't a whistleblower. Okay. So the judge, again, remember, he will repeat the point. He's not making the point that's illegal. The judge is repeating the point. He says, the judge didn't counter. This is so wrong. The judge is not allowed by law to counter and say that the whistleblower argument by saying what he expects prosecutors will say. The judge did say, when the defense was making this point, I suspect the prosecutors are going to say, in cases like this, when an investigation begins, the guilty party realizes the gig is up and she pushes to provide documents. He added that this behavior is not necessarily proof of innocence, but is sometimes evidence of a guilty mind. The judge didn't make that point. The judge said, I suspect that's what the prosecutors are going to say. But WMBB says that the judge countered the defense. That is an absolute, I'm not going to call it a lie, because maybe Brady Calhoun with WMBB, maybe he was nodding off at that point. Maybe he was hungry. I get hungry. I'm not thinking right. Maybe he missed it. Maybe it was a mistake. But there are a lot of mistakes, a pattern of mistakes in WMBB's reporting that is causing the community to be misled about the evidence that was presented in this evidentiary hearing. The judge didn't counter that. And that's an important point. It's so important that WMBB ought to make corrections to these things and broadcast it and publish it. These are egregious. In cases like these, we already said that. This is the end. Both sides, so now that's where we are. Both sides have several weeks to file paperwork connected to these hearings. The judge will then be able to rule on these issues in late May. All right. So that's that's where we are right now. Both sides will file. What is the judge going to consider? The judge is going to consider a couple of things primarily. He's going to consider whether there were Sixth Amendment violations in the prosecution side. Did they violate attorney-client privilege on several different issues? And he was very, very concerned about that. That's one thing. Number two, he is going to consider whether or not the dozens of false statements made to the grand jury, were those neglectful? Were they mistakes? Or were those, does it show a pattern of willful mischief in order to obtain an indictment? Now, how would that be proven? Well, it might be proven if the defense can show that they had given the prosecutors evidence, not just arguments, evidence that's counter, completely opposite, and not just given, but told. If the defense lawyers had told the prosecuting lawyers weeks before, months before, and provided documents and evidence that say one thing, but the prosecution tells the grand jury something else entirely. If the judge says there's a pattern of that, he can dismiss this case as a matter of law, and it will never go to trial. These are the types of things that the judge is going to consider after receiving the written paperwork in which both sides will argue the facts and the evidence and case law. That's what the judge is going to look at. Do these rise to the level that he has to dismiss this? Because either the evidence is tainted or because of willful mischief on behalf of the prosecution, Sixth Amendment violations, attorney-client privilege. These are the things that the judge is going to weigh. These are the things that the judge is going to weigh. All right. So I'll look over your comments. This is a very, very interesting case. The ramifications go far, far, far and broad. I'm still putting a lot of things together. I'm still trying to figure a lot of things out. And I don't even know what to say. But it's really a big deal. So, and I'll tell you this, what I think. If it's dismissed, somebody texted me today, I think, and said, so do you think they're going to walk? And I wrote back one word. I said, walk? ? He said, well, the mayor and the developer. And I said, well, that implies that they're guilty and they're going to get off, and that's wrong if they walk. I said, now, if the question is, do I think that the judge will dismiss the case? I think there's a good chance. Again, if I were to bet, I think that it's going to go to trial. But it's a close one, in my opinion. And I'm not burning the attorney, right? I'm just a guy watching, trying to figure it out. So I wouldn't consider that walking. I might consider if a target of the investigation is given full immunity after ill-gotten gains amounting to millions and 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 millions, I think that's about right, dollars, is given full immunity to testify, that might be walking. So I think some people are walking. But if the judge dismisses this based on a matter of law, because of some serious problems that I've seen in court, evidence, I don't consider that walking. So don't be shocked if it's dismissed at the end of May? Yeah, I think at the end of May. But if you're betting on it, bet it's going to go to trial. And if it goes to trial, we are not going to believe the evidence presented by the defense, because they're going to call a lot of people on the stand. And if the questions are as tough in a trial, and they will be, if the questions, look, I got all blurry. Hold on. Look at that. If the questions are as tough in the trial, and they will be, as they were on the FBI agent who was sitting in there for an hour and a half, getting hammered and not answering in a very confident way. What's it going to be like when they pull up a bunch of other people and they provide evidence and said, you said that, but the evidence says this. You said this in July, but the prosecution actually said this in June. What about it's going to be, we are going to hear things. If this goes to trial, we're going to hear things that are going to be shocking. So we'll get to that when we get there. Look, if you want others to hear this perspective, I'm going to ask you if you'll tag your friends, if you'll share the show, if you'll share it on your page, so that people can see this. This is what I saw when I went this week to the evidentiary hearing. And if you want to support my work, I hope you will. I hope that you'll become a patron. It's a way to support what I do. It's sort of like a tip every month for as little as $5 at patreon.com/Bernie Thompson. And it is anonymous. Nobody knows it's you, which is always helpful, right? You're supporting Bernie. They will never know. The second, because this show is supported by crowdfunding and supported by sponsors. So that's why I can tell you the truth. Because I refuse and I walked away. I will not work for a media outlet that says I have to lie to you. Won't do it. So if you want to support my efforts, this is one way. Patreon.com/Bernie Thompson. It's anonymous, it's easy, and you can quit at any time. And I also want to thank, of course, the Unknown Patriot, one of the sponsors of the show that helps me do what I do and helps me bring the truth to you, at least the best I see it. Now, I want to say something about that too, by the way. Am I always right? No. I like to say I'm the first to admit when I'm wrong. It's just I'm usually the last one to know. But if I'm wrong, I'll tell you I'm wrong. I don't always have the truth because the truth can be elusive, right? But I'm committed to pursuing the truth and to telling you the truth based on the evidence and the reasons and information and belief, the best that I can tell you. All right. Also, on a separate note, as a paid political ad, if you are a Panama City Beach voter and you are looking and you're not happy with Jeff McConnell as representing Ward 3, any Panama City Beach voter, whether you're in Ward 3 or not, you can vote for this candidate, and I hope you do.
Hi, I'm Mary Coburn, and I'm running for City Council in Panama City Beach. For me, it's about respect. Respecting our residents, respecting our quality of life, and respecting our environment. I'm tired of feeling like a second-class citizen in my own hometown, and I'm sure you are too. Tourists are important. They're our very livelihood, but they're not more important than you. Council members should represent their constituents and not focus on developers, contractors, and consultants. If you agree with me, vote Mary Coburn on or before April 19th.
All right. Thanks for being with me. I'll continue to keep a close eye on the trial, or not the trial yet, may not be, but the case, right, of Margo Anderson, the former mayor of Lynn Haven, and developer James Finch, developer James Finch. The reason I'm focused on it now is because it's game time now. The reason I did not report on Lynn Haven throughout 2018, 19, and all of this stuff when there was real corruption going on in Lynn Haven for which many have pleaded guilty, is because I'm one guy walking a tightrope with no net, trying a business model I don't recommend for anybody, focused on Panama City Beach, where I thought there were the biggest crimes. Well, there were big crimes in the county commission too, and in Panama City, and in the school board. But I can't cover everything, right? If I scatter my reporting, I don't make an impact. But I did not see anything rising to the level of the county commission and Panama City Beach in Lynn Haven. And so I wasn't reporting on that stuff for these reasons. Why am I reporting on it now? Because it's game time. There's a trial that could be coming up. A local mayor could have committed, and a local developer could be guilty of fraud and bribery, or they could be not guilty of fraud and bribery. And based on the evidence presented in court, I'm going to continue to report on it for you so that you have another vantage point outside of WMBB who is reporting information to you the same way that the prosecutors reported allegations to the grand jury. How do I know this? Because I saw the transcripts and I saw the evidence. They were either a whole bunch of really bad mistakes or willful mischief to get an indictment. And I don't know that answer yet. The judge will decide. But it didn't look good for the prosecution. All right, I'm going to wrap it up, and I'll see you soon. Thank you for being with me.